So this next case, Mitchell versus Hutchinson, is going to take us back to law school days and the famous case of Summers versus Tice. So in this case, the driver of a Ferrari, lucky guy, is driving through Dana Point when he crashes into a bunch of rocks in the roadway. And he doesn't know exactly where the rocks came from, but he can tell that they came from one of several abutting property owners. So he sues all of the property owners under the joint liability theory of Summers versus Tice. As you may recall, in Summers versus Tice, two hunters fired a gun negligently in the plaintiff's direction. One of them hit the plaintiff, but the plaintiff couldn't figure out which one. And the California Supreme Court held that under those circumstances, the burden shifts to the defendants to basically show the shaggy defense. It wasn't me. The plaintiff here tried to invoke that argument as well, but wasn't as successful. One of the defendant property owners moved for summary judgment, saying, well, the plaintiff has absolutely no way of showing not only which place the rocks came from, but also that I even acted negligently in maintaining my property. And that was true. The plaintiff could only surmise that the rocks came from one of the property owners, couldn't figure out which one, and because the defendant here was able to show that the plaintiff had no evidence she acted negligently, she was not a wrongdoer. And if she's not a wrongdoer and not a tortfeasor, then the joint liability theory under Summers versus Tice doesn't apply. Because again, that situation only works where all of the defendants are wrongdoers, and you just don't know which one of them is the actual cause. So here the motion is granted and affirmed on appeal. Interesting case, hearkening back to the days of yore of law school.